16, 15. Respondent number 3. Okay. Your name? S. Please write it down. I'm not getting the name. Learned counsel appearing on behalf of Mr. B.K. Das, learned counsel for respondent number 3, submits that he has taken consent from the appellant for adjournment. Next point. Here is prayer for adjournment is allowed. List 24 matters. Give a date after. Okay. God. You want to see the records? You want to see the records? You want to withdraw it? I took 4. Okay. Both sides are represented on the prayer made by Mr. J.M. Suleiman, learned counsel for the petitioner. Is permitted to withdraw this petition with leave to with liberty to approach again. So, accordingly, the matter is dismissed on withdrawal with liberty as paid for. Achha, you don't say so and so. Give the names, respondents. Huh? Heard so and so. Yes. Just wait. Item number 36. You got it by order. This is brought by order on mention. No. After getting mention, you don't take adjournment. But you made a mention. This has come by way of a mention. No adjournment. Yes. '21. Okay. Let's. 2nd of March would be difficult because it's sandwiched between 2 holidays. No. 9th of March. 11th. Okay. Both 20. Item number 21. Okay. Both sides are represented on the pair made by Mr. R.M. Dekar, learned counsel for the petitioner. Matter stands adjourned today. List on 11/3/2026. Okay. Yes. Okay. 14. Year for the petitioner. If both sides are represented on the prayer made by learned counsel for the respondent. So the matter stands adjourned today. This round, give a date after 2 weeks.
Take lordship. So I declaration item number 16 and 17 lordship. That's 16 and 17. That's the service matter lordship. In the 16 I am the respondent, and in the 17 I am the appellant lordship. That's the cross appeal lordship.
So in 16, item number 16, I am for the appellant, and 17, I am for the private respondent.
Yes, lordship.
The 2014 matter, lordship, a date may be fixed.
No,
There's-
24 matter. 24 matter.
But the pre-petition is 2014. Lordship, a date may be fixed. They have some difficulties.
Yes, lordship, we had some difficulty.
Yes.
Lordship, maybe lordship taken up as far as
Subject to convenience, lordship, on 24th of March.
Both sides are represented on the prayer for adjournment made by Mr. S.
Hawk.
learned counsel for the appellant in WA 159 of 2024, respondent in WA 159 of 2024, and the appellant in WA 169 of 2024. The matter stands adjourned today. List on this date.
Hello.
Supplementary item 37 for delivery of order.
This writ petition is dismissed.
Daily list item 1 for motion.
My lord, in this case, I am praying another 1 week time, lordship. Yesterday, I have made communication, lordship. Yesterday, I have made communication regarding registration certificate.
Yes,
lordship.
yes.
Yes, so, lordship, otherwise, lordship may also direct me, government advocate to place the instruction because I have to obtain it from the concerned DC, lordship. We have.
See the main part.
Yes,
Who is the concerned deputy commissioner?
both Dorong and Sonitpur, lordship.
Yes. There's a registration certificate. Look at that document. We will show it to you.
Nice.
We want to get information about this.
We have.
Both Dorong and Sonitpur may.
Dorong, perhaps it is now under Sonitpur.
No, sorry.
We'll ask both of the deputy commissioners,
yes,
wherever
yes,
the record is, give him a photocopy again.
Photocopy and one copy of this petition also now.
Huh?
No file is there. 2019.
But Mr. S.C. Dasnan comes for the petitioner.
Okay.
No, not that fine. Also, it's photo respondent. Next paper. In course of hearing, the Learned Counsel for the petitioner has produced the original exhibited copy of the certificate of registration, which was approved and marked as Exhibit D before the foreigners tribunal number 8, H4. Next one.
I hate to know.
In view of the contents of the said document, the learned senior government advocate praised for and is granted 10 days time to have the to page number 13. To fill specific instructions with regard to the said certificate of registration, which is purportedly issued in exercise of power and authority under Section 5 within bracket 1 within bracket small a oblique small d of the Citizenship Act, 1955. We request the learned counsel for the petitioner to provide photocopy of the said document as well as a copy of the writ petition. The learned senior government advocate to enable him to obtain instructions. You can you give it in a soft copy also? The read petition. Yes. Hard copy and a soft.
What are the?
Say it by 26 to 2026. You will give the copy within 26 to 26. They're giving you 10 days time. We want to know about the document.
Only dog, 2 weeks. Perhaps.
2 weeks. Okay. Give a fixed date. Just before that, you say that the additional senior government advocate is permitted to send a downloaded copy of this order to the district commissioner, Sonitpur, Tejpur, as well as to the district commissioner, Mangaldev, to enable him to obtain instructions.
It will be next to.
Item 2 for motion.
Map. What do you say? And then was directed from police some. Instruction from deputy. It was good. Among the years. Rakhai. Rakhai. One, two, three. Next up, banana simple. 30, 1, 3, 1, 3. 55, 56. 50. Correct बोली कोई से ये तो ऐसा नहीं है, ये क्यों जाना है बस तो मोर ना है ना तो भी इसका और नाम जवान में रासायन है तो इसको और डेटा का नाम हाँ और डेटा का originally maintained 1958 consequently is Jamanandi book certified the Jamanandi issue money verified so the Jamanandi book and found correct पैसे बोले कोई से मुझे ना सर नाम सर नाम देवता रस এটা তুমি জানা मैं तो पिछले बार आने की शोर तुम कोरी यार कम से कम बहुत बार तुम कोरी नेक्स्ट है तो मैंने शेयर रखी हाँ सेल्स के बाद 55 बस others, Hasan Ali আছে আছে সেই বাপের নাম হাসান আলী
Almost any.
হরমুজ হরমুজ কোড আছে এর নাই
That's six number.
হরমুজ হরমুজ আছে দেখলাম হরমুজ আছে
Herein, your lordship, basically the
তোমার একজন
ground of declaring the petitioner as foreigner is that no voter list in between
জওয়ান মন্দির খেতেও কোয়া জওয়ান মন্দির তো কোয়া জওয়ান মন্দির তো কোয়া Manager 1919. Regarding submit regarding Jaman one, the other documents are no problem. You submit no problem. It will not be there. It is- Jaman number six.
regarding the instruction, your lordship, I have also found that, and they have admitted that the content of the Samabandi is correct, your lordship. And in my case, your lordship, only the fault was that the petitioner failed to submit the revenue paying receipt in respect of that land. And that revenue paying receipt I have annexed here with this petition, your lordship. And in the Samabandi, it is very much clear that the father's name of the petitioner appeared therein at Patadar number 6, your lordship, in page 56. And the ground cited in this input opinion is that the petitioner failed to submit voter list in between 70 to 1989. In 1917 to 1989, there was no any voter list. And the revenue paying receipt was not submitted in respect of the land, which has been annexed as Annexure 39, your lordship. But in my present petition, your lordship, I have annexed the revenue paying receipt, that is at page number 61, your lordship. Page 61. Page 61, your lordship, it is written that Karpura Pua Hall, Hurmus Ali, and he is the father of the petitioner. Karbabe Pua Hall, Hassan Ali, Nasimuddin, Hurmus Ali, that means Hassan Ali, Nasimuddin, Hurmus Ali, they are the brothers, your lordship. And grandfather's name of the petitioner appeared in the voter list of 1966 and 1970. And the father's name appeared in 1989 onwards. And the name of the petitioner, his name appeared in the voter list of 2005. And the Annexure 13, your lordship, it established linkage in between the father of the petitioner along with his grandfather, your lordship, whose name appeared in the voter list of 1966 and 1917. In the NRC of 1951 also their name appeared, your lordship. Yes. What 42, your lordship. No. It will be, I'm sorry, your lordship. 84. 30, your lordship, it will be. Yes, 30. In 1989, his father name appeared, and in the voter list, his age is shown as 30 years he was at the time. In page 65, your lordship, one Gauhati certificate, it was produced, and it was also proved, your lordship. Page 65. Huh? minus 30. Yes. Page 65, your lordship, I'm reading, your lordship, what is the certificate, your lordship? উক্ত মানুহজনৰ 1966 ইংৰাজী চনৰ ভোটাৰ তালিকা মতে ক্ৰমিক নম্বৰ 56, ঘৰ নম্বৰ 56, খৰণ নম্বৰ 56, সমষ্টি নং 50 নং বৰপেটা বিধানসভা সমষ্টি 1970 ইংৰাজী চনৰ ভোটাৰ তালিকাত ক্ৰমিক নম্বৰ 56, ঘৰ নম্বৰ 56, সমষ্টি নম্বৰ 56, 1970 চনৰ পিছত দানেশ আলীয়ে তেওঁৰ ল'ৰা হুৰমুজ আলীৰ লগত লৈ বৰপেটা মৌজাৰ গৰৈমাৰী পথাৰ গাঁৱত সপৰিয়ালে বসবাস কৰি আছিল। That means it was not considered on that ground which has been cited in the opinion at page number 34 in para 12, your lordship. The ground of rejection of this application, why it was not considered. In 1966, your lordship, 66, in page 37, your lordship, this is the legacy data, your lordship. And it was in respect of the grandfather of the petitioner, your lordship. Page 34. And 38 is the voter list of 1966, wherein the name of the grandparents, as well as the paternal uncle of the petitioners appeared, your lordship. And page 40 is the voter list of 1970. In fact, all the names, your lordship, will find in the Jamabandi copy, your lordship, in page 55, your lordship. The person whose name appeared in the voter list of 1966, their names also appeared in the Jamabandi copy, which has been annexed at Annex 13, your lordship. And the father's name, 1989 to till date, your lordship, his name has been appeared in the voter list. And the name of the petitioner from 2005 onwards, his name has been appeared, your lordship. So I think the ground, your lordship, whatever cited by the honorable member, your lordship, is not correct and is not correct, your lordship, to the effect that the ground they have cited that the Jamabandi copy, the which has been relied by the petitioner before the tribunal, no such copy of revenue receipt has been submitted, your lordship. It was one of the ground, and the next ground was given that there was no any voter list in between the period 1970 to 1989. And the Gaura certificate was not considered on the ground that he was not the Sarkari Gaura. Village, Your Lordship, the father was born and brought up at village Palhazi. But after 1970, the grandfather of the petitioner, along with his father, they shifted on the opposite side of the road, which falls under the village Goraimari Pathar. But in fact, both the village, Your Lordship, within the jurisdiction of same Panchayat, Your Lordship. That is the Palhazi Gaon Panchayat. That shifting is not the matter here. Before 1970, they were on the other side of the road, which was Palhazi. And after 1970, they shifted on the another side of the road, and that is the Goraimari Pathar. But both the villages within the jurisdiction of Palhazi Gaon Panchayat. Page 65 is the Gaura certificate, Your Lordship. 64, Your Lordship, is the type of it. It's 65.
Daniel, ল'ৰা ছোৱালী লগত লৈ বৰপেটা মূল বৈৰামী পথাৰ গাঁও page 64 Bangalore side লৈ অলপমান ভিৰ থকা যেন পাইছে এই person সংগঠন নাকি audit Eleven. Makam. Interim of national estate. Do what I would do is- No? Huh? Apa? Ya. Nanti. Nanti. Kita ko ba nakakari? Ito. Nanti nikeli. And what timing of this is? It won't be to the channel. It will. And, oh, we don't need to. What time will it not, I don't know.
Alright. From the instruction, Your Lordship, I just want to say one thing, Your Lordship. From the instruction, it is written that the original Sadar Jawabandi book was maintained from the year 1958 to 65 and continuously updated the subsequent entries in the e-Jawabandi book. The certified copy of Jawabandi issued by so-and-so is verified with original Sadar Jawabandi book and found correct. Now, Your Lordship, in page 38, Your Lordship, the person whose name appeared in page 38, their names also appeared in the Jawabandi copy, Your Lordship. Page 38, Your Lordship, page 38, all the person names appeared in the copy of the Jawabandi in page 56, except the father of the petitioner. But the father of the petitioner, his name appeared in the Jawabandi, but in page 38, his name is not there. It means page 38 is the voter list of 1966. At that time, he was not, he did not attain the age of adult franchises, and accordingly, his name was not there. But in the copy of the Jawabandi, his name is there, along with all the persons whose name appeared in page 38. So my humble submission is that, Your Lordship, this is a fit case, Your Lordship, and he has discharged his burden before the court below, before the tribunal, but it has very illegally rejected, Your Lordship.
Yes, Lordship, Lordship, this Jamabandi copy, Lordship, page 57, this land was obtained not by way of inheritance, Lordship. It is, Lordship, here it is mentioned as Onghidar Hutre. In the year of 1972, Lordship, their names has been mutated. And although if we consider it as a genuine document, Lordship, then also, Lordship, petitioner is not able to establish his link with his projected parents, Lordship. And Lordship, 1966 voter list, page 39, Lordship. These are the entries: Danesh Ali, Tukijan Nesa, Nasimuddin, Samejuddin, Ramejuddin, Tamejuddin, and Zamiran Nesa, Lordship. Then, Lordship, 1970, page 40. Although it is a translated copy, Lordship, here also same entries are recorded, but after 1970, Lordship, in 1970 to 1989, Lordship, there is nothing, Lordship. And tribunal has discussed all these things, Lordship. And here in 1989 voter list, one Harmus Ali name was entered, Lordship, at the age of 30 years. And projected father's name is, grandfather name is here Dagesh, not Danesh, Lordship. And village is also different. Village is also different. And Lordship, if we see the WS, Lordship, nowhere proceeding has stated that they are earlier residing at village Palhaji Gaon, but here, Lordship, regarding that, and Lordship, WS is totally silent regarding when his father has died, Lordship, when they have shifted from Palhaji Gaon to this Garemari Pathar village, Lordship. All these things are not there in the WS, Lordship. And although Gaubura has adduced evidence in this regard, Lordship, but those are not based on any record, Lordship. And oral statement is not enough to prove one's citizenship, Lordship. Then after 1989, Lordship, and after 1989, 1997 voter list has been placed. Then at page 46, Sohidul Islam's names first time appeared in the voter list of 2005. So Lordship, 1989 voter list and 1997 voter list cannot be accepted as a linked document because Lordship, here proceeding has to prove that this Dages, Hormuz Ali son of Dages, and Danes Ali mentioned in 1966 voter list is the same and one person, Lordship. And there is no such document to prove that these two persons are same and one person. Lordship. Other connected persons are not there in those voter list, Lordship. Suddenly, one Hormuz Ali's name appeared in 1997 voter list as well as in 1989 voter list, and all the entries are new, Lordship, in this voter list, Lordship. So, Lordship, I am frequently relying this decision, Lordship, Aziz Mia's case, para 14, 2023 for GLT 246. 2023 4 GLT 246 and connected WBC number is 2370 of 2023. Para 14, I am just reading, Lordship. We are constrained to observe that mere claim by a suspected person by referring to a voters list, claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voters list relied upon this actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So, Lordship, in this case, petitioner is lack of such materials by which he can substantiate his link with his projected father, whose or grandfather, Lordship, whose name appeared in the voter list of 1966. And if we accept the Gaubura evidence, then also, Lordship, it cannot be accepted as a valid evidence because oral evidence is not enough to prove one's citizenship. And Gaubura's evidence, what Gaubura says, only on the basis of personal knowledge, Lordship, and not on the basis of record, Lordship. And regarding that, Lordship, 2018 4GLT 373, I am relying connected WBC number 3807 of 2016. কপিখনত শহীদুল ইছলামৰ নাম আছে নেকি? So, Lordship, regarding Gabra's certificate, Lordship, I am relying this decision, Lordship, 2018 4 GLT 373. Connected case is WPC 3807 of 2016. Two 4 GLT 373. 2018 373. ROMILA Romila Khatun KHTUN. Para 22, I am reading. It is tried that documentary evidence would have to be proved on the basis of record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of content is another. Not only the document would have to be proved, but its contents should also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from record. A document or contents of document cannot be proved on the basis of personal knowledge. And Lordship, if we see the Gaubra certificate, Lordship, at page 65, Lordship, what Gaubra certifies, Lordship? উক্ত মানুহজনৰ 1964 ইংৰাজী চনৰ ভোটাৰ তালিকাত ক্ৰমিক নং 44 ঘৰ নং 378 খণ্ড নং 91 সমষ্টি নং 50 বৰপেটা বিধানসভা 1970 ইংৰাজী চনৰ ভোটাৰ তালিকা 1970 ইংৰাজী চনৰ পাছত দানেশ আলীয়ে তেওঁৰ ল'ৰা হৰমুজ আলীক লগত লৈ বৰপেটা মৌজাৰ গেৰেমাৰী পথাৰ গাঁৱত সপৰিয়ালে বসবাস কৰি আছে। But Lordship, nowhere proceeding has stated that they are earlier residing at Palhaji Gaon. Lordship, then I could not find, Lordship. So, Lordship, if Gaubra's certificate goes, Lordship, this land document goes, Lordship, then nothing will remain, Lordship, to prove his linkage with his projected parents. And there is a gap of more than 19 years, Lordship, since 1970 to 1989. Regarding that period, there is no explanation of the proceeding, Lordship, which is mandatory as per section 6A2 of the Citizenship Act, Lordship. And all these things has been discussed by the learned tribunal. So, Lordship, there is, my humble submission is that there is no infirmity in the opinion passed by the learned tribunal. So opinion may not be disturbed. Lordship. And tribunal passed the opinion only on the basis of what is available, what materials available on the record, Lordship. That much only.
Very simple. Itu bisa yang sekarang itu recorder.
From the Additional District Commissioner from Borpeta. The same is detailed on.
Number after the 11
Item 3.
Okay, scripted is the opinion. There is a delay about 3 years.
एकदम ठीक $22 order.
Yes, 58 month.
This is application.
In view of the delay in assessing the influent opinion, keeping the issue of maternity open, you should notice returnable on so and so. Extra copies of the previous conflict records. Therefore, bail shall be considered on receipt of the tribunal's records. Next one. If in the meantime, the petitioner, Asiruddin, alias Azaruddin, alias Adio, three names, huh? Page 2 is apprehended, he shall not be deported out of the country without order of the court. So, the petitioner shall cause production of a certified copy of the order before the Supreme Police border. This place.
Barbatam.
Brings the order to the notice of the center. List on swings.
Daily list, item 5 for motion.
May I please, your lordship. So, contested case, my lord. The kindly. The impugned final order at page 109, my lord. Page 109. Only.
Mr. S. Ahmed, the petitioner, and so and so for the respondents.
NRI.
Opinion page 109, dated so and so. In FT case number so and so. SP reference case number so and so. By which the petitioner was declared to be a foreigner of post 25/3/1971. Notice returned in 4 weeks to the court, extra copies within 2 days. Therefore, bail is opposed by the learned standing counsel for the FT and otherwise. Considering the projection, then just the satisfaction of
Yes, Nolbury, my lord.
SP
SPB Nolbury.
within bracket border closed on nobody. Let's start with points.
Obliged, much obliged, lordships.
Item 6 for motion.
May I please, your lordship, my lord, the matter is related to red judicature, my lord. My lord, the petitioner has already been declared as not an illegal migrant, by order dated 2/4/2011, my lord.
Page.
My lord, may I first refer to the impugned order, my lord, at page number 84, my lord. 84 is the impugned order, my lord.
Page number.
My lord, page number 84, annexure 15, and my lord, the relevant portion is at page number 85, my lord, finding of the learned tribunal. So second paragraph, as the record was called for, my lord, therefore, my lord. My regulation states. As the record was called for from the Furnace Tribunal number 1 Golpara, Assam, and same is received on so and so. I have gone through the records. While perusing the records, I find that the name, father's name, and address of the proceeding has been enlisted in the reference case of Furnace Tribunal number Goalpara, Assam, as Nur Hussain, son of Khundagar Abu Said of village Sunahara Pias, Goalpara, RPS, district Goalpara, Assam, and as recorded in the instant proceeding, as MD Nur Hussain, son of Abu Said Khundagar, and the address is recorded as village Sunahara Pias, Bhagwan district Goalpara, Assam. So in both the references, the name of the father of the proceeding and police station are different. Moreover, in application number so and so, which was tried in Foreigners Tribunal Corporation, is a ERO case, right? ERO case number so the instant reference is right FT case. These are the anomalies the learned tribunal has detected, and the moreover the two different. There shall not be two proceeding against the same proceeding in two different references or two different foreigners tribunal upon the same issue, however competent it is. In other words, once a foreigners tribunal decides whether an individual is a foreigner or not, the same issue cannot be raised in another foreigners tribunal to redress it again. Moreover, the plea of res judicata under section 11 of CPC is founded on proof of certain facts and then by applying the law to the facts so far. These things are relevant, my lord, and the subsequently, my lord, the petition has been rejected and the petitioner has been directed to file his WS, my lord. And thereafter, the petitioner approves this honorable court, my lord. Now, my lord, the finding of the learned tribunal that the father's name is different, my lord. Kindly have a look to the notice, my lord, in first case, my lord, that is at page number 28, annexure 1, my lord. Original photocopy of the original is at page number 30, my lord. Nur Hussain, son of Khundokar, Abu Said, village
But you are
Sunahara.
showing us the opinion earlier. Where is the earlier opinion?
Opinion is at page number 73, my lord.
District Lordship may call for the records and examine the matter, Lordship. There are a lot of corrections also in the first opinion. There are a lot of corrections also in the first opinion, Lordship. Handwritten corrections are there, Lordship. Let the records come at this stage.
the petitioner, namely Noor Hussain, NURHUSSAIN, was declared to be not a foreigner by the opinion dated 2/4/2011, passed by the learned members of Foreigners Tribunal, Gauhati. Next, on receipt of the notice in connection with case number. Opinion dated 2/4/2011, passed by page 73, passed by so and so, in FT case number so and so, ERO case number so and so, declaring to not a foreigner. On receipt of notice of the proceedings of case number page 84, case number so and so, FTG case number so and so. Is another reference FT case number so and so. From the Foreigners Tribunal Court, Gauhati. The petitioner had filed a petition on 30/11/2024 for dismissing the subsequent proceeding on the ground of res judicata. The said prayer was rejected by order dated 23/4/2025, which is put to challenge in the present petition. Next one. If you notice, returnable on, give a fixed date of votes, returnable on also. Requisite extra copies of the petition is served to the under CG State and Department of Consular Affairs. Let the records of page 73 and the records of page 84 being called from the concerned tribunal. So the following email addresses. Here you will say that Foreigners Tribunal, Gauhati, the address, and then
Well, Foreigners Tribunal, Golpara has now been renumbered as Foreigners Tribunal number 1, Golpara. Earlier
number
it
one
was,
Gauhati.
yes,
Number
number 1,
one.
Golpara.
Number 1 Gauhati. And the second is page 84, repeat number 2.
Number 4.
Foreigners Tribunal, Gauhati, number 4 Gauhati. Next list on students.
Well, further proceeding may kindly be stated.
We're calling for the records. What will happen without records?
Well, even then, well, further proceeding may kindly be stated in the minute.
Records are not there, how the
We're
proceeding will
calling for the
continue.
records. You-
27th of March.
This order was passed
Last year.
Now you are coming after a year.
No, my lord, in the last year I have filed this petition, my lord. Yeah, my lord,
There did not seem to be any urgency, lordship.
no,
It
my
was
lord,
filed sometime in the month of June last year.
no, I have.
It was fixed for WS in the.
You see
month
that
of
that
June.
is
In that month of December, I have filed this petition. All right, my lord.
Item 7 for motion.
So this is contested case, Lordship. The opinion is at page 78, Lord.
But we say you the Learned Counsel for the affected and also for the respondents. Page 78,
Yes.
dated 19/3/2025, passed by so and so in FT case number so and so, police reference case number so and so. Thereby declaring the listener to be a foreigner of post 25/3/1971. Notice determined in 4 weeks. Extra copies in 2 days, all for the reports, the following even assess. Prayer of bail is opposed by the learned standing counsel for the FT matters, considering possession. 10 days time to take bail of this petition, dissatisfied. So if no police, then they get border, it go more account.
So I have to appear before respondent.
This Burma is something which struck us. Please come to page 78.
Yes, Lordship.
78, you will find that there are as many as 8 proceedings.
Reference will, we'll have to look into the record.
We don't know, but this is how it proceeds.
Yes,
We
Lordship.
fail to find that the proceedings are dropped against others. And then in paragraph 13, page 81, the tribunal says that the petitioner has miserably failed, about 6 lines from below. Page
Ne-
81.
Next page at 79, the High Court order has been quoted, Lordship.
Hmm?
Next page at page 79. Therefore, in all the above 57 references,
No, that was because of the orders of the court. This was found to be disposed of, but no orders were passed.
yes,
That is why it was
it was
reopened.
taken up again, Lordship.
The paragraph 2, page 78, that you will find. Of this case to be reopened. This was suo motu 11 of 18. So these were reopened.
Yes.
No orders were passed. But this 8 reference, reference against 8% was whittled down.
In
Only
this-
opinion
in this-
against 1.
In this case, Lordship, there is, let's the dual opinion. In the same case, 2 opinions are, that is why Lordship does.
Let the records come because Lordship, the records will reveal whether
Let's,
inquiry report is against all the 8 people or against 1 or 2
No,
people.
that's okay. He gave an explanation because we did not notice that.
yes,
Did you make a statement here about 2
no,
opinion?
no, only in respect.
That's why.
And Lordship, earlier in 2 cases, he was declared.
That because if we are missing something, we must know.
No, Lordship, I'm on different. FTC case number 66 of 2015 and FTC case of 161 of 2016. In these 2 cases, he was declared to be Indian. That may be also, the 2 cases may be called record.
Where is that?
Lordship, regarding that matter where he says he was declared to be Indian, I think he filed a writ petition also in 23 relating to that.
Yes,
That is at page
page
73.
51 is the first opinion, 24 to 2016.
This statement, is challenged when so, then next para. It is further submitted that in two previous proceedings, which were numbered as FT within bracket C, 66 of 2015. In two proceedings, the petitioner was declared to be not a foreigner, for which he places reliance on the opinion dated 24/2/2016, passed by
Same tribunal, Lordship.
the same learned tribunal in FT within bracket C, bracket close, 66 of 2015,
2015.
and opinion dated 10/4/2018, passed by the same learned tribunal in FTC 161 of 2016.
60.
Now, when we're saying all the records, three records were to be followed. Why this number you will find at least 79. It's two numbers. Prayer for bail is opposed by the learned, 10 days time we have also said.
Obliged, Lordship.
This matter goes back to 2019, Lordship, when the tribunal had not passed. Yes. It was taken up so moto by this court. Lordship, it just called for the records now. No interim, interim granted.
Item 8.
May I please, your Lordship? Lordship, into an order at page 46. In this case, my lord,
Sharma, looking at Mr. Das, we remember that in the earlier case, that certificate was shown. We want to know who will have the records, and if the records are available in the Deputy Commissioner's office. That certificate of registration as citizen. Who is the custodian and where it will be available? Therefore, if required, we will call for it. And if they have copies, they can send that also. If they have, they can locate the record. Just say that whether it is correct or not. Or give their copies. They can make photocopies and then authenticate it and send it out. Yes, Mr. Das.
my lord. So in this case, my lord, petitioner had submitted her written statement. Thereafter, she fallen illness, and for that reason, adjournment petitions were filed on
Where is the opinion?
6/1, my lord, at 46.
46.
Yes. So, my lord, here 4 consecutive dates, she remain absent.
Okay,
So-
got the record.
Oh,
You have enclosed the order sheet.
my lord,
Have you annexed the order sheets?
order sheets, I have not annexed, but adjournment petitions I have annexed here. And literally it is gone for expert opinion. So after WS, she could not adduce any evidence. So otherwise, in WS, my lord, she has filed some documents showing her lineage with her Indian parents, like voter list of 1966, 71, 77, all this are my lord. on 6/1/24, 7/2/24, 6/3/24, and 25/4/24, 4 adjournment petitions were filed.
What is the serious illness?
My lord, it is stated that she was suffering from jaundice and its related complications.
Jaundice
Well,
can't be believed.
But no medical certificates were submitted.
Jaundice for so long can't be believed.
Yes, my lord. Medical, no certificate was produced. My lord, my humble submission would be that since our burden of proof has not been fully delivered, so a chance may be if lordship may please to provide, then she would very much
Again,
ready to.
you have approached after about more than 1.5 years.
My lord, it was passed on 12/6/24, yes. But due to her, I have stated in my petition that due to economical, her financial condition, she could not approach in time before this proof. So this aspect, I am praying for leniency in this case. But and also an illiterate woman having the knowledge about these complications of law.
Well, nobody knows law well.
My lord,
Even we don't know the law entirely well. We also say we are learning. Don't we say in the court, we are also learning.
my lord, there is a delay, I admit it. So if otherwise vital documents are, she poses. In the opinion, my lord, so far as concerned with the annexures annexed with the writ petition, were not discussed and whether they carry
Where is your
evidentiary value or not. Written statement at page, my lord, 438, 39, my lord, annexure 14.
21. So much high. Nineteen. So
My lord. My lord. My lord, written statement. My lord. My lord.
Our copies do not have any signatures, Lordship.
Yes, my lord. Yes, 453. আমার লগত একটা প্লেট আছে না?
Completely different.
Different আছে।
Written statement first. बुरा कौन है?
জানো? এটা হলো সেম আছে। ভালো।
আপনি ইয়াতে আপনার কিন্তু এফিডেভিটত বেনে
এটা আছে। এটা তো সেম আছে। এটা জামালা খাতুন।
কিন্তু এফিডেভিটত একদম বেলেগ। পিটিশনার ক্ষেত্রে আমি বহু দিয়েছি।
কেতিয়া বলা যাবে? After a week. Madam. After a week, any date, madam. Madam. Yes. March of 10, 11, sir. 12 or 13. As at 12 or 13. Well, on 12th of March, 12 or 13.
One actually barn. We can get it. Lordship will communicate a downloaded copy, Lordship. I want to keep it straight. Mm. 16, Lordship. 12, she will come, yes, Lordship. 16 free.
Lordship.
Lordship, we have to collect the records from the tribunal.
Item 9 for motion.
Maybe Lordship. Lordship, in this case, the opinion is at page 22. It is of order dated 26/12/25. 6/12/2025. At page 22.
Passed by so and so in FT DB case number so and so, FTSP reference number so and so. Thereby declaring the petitioner to be a foreigner of post 25 in 1971 street. Notice return to Bobix for the records, the following email address. And therefore, bail is opposed by the learned standing counsel for the FT and border matters. Considering the projection, 10 days time. The petitioner to take bail of rupees 5,000. This satisfaction more. Deputy Commissioner of Police Border, Kamru Metro Gauhati. You have arrayed him as respondent.
Pardon, Lordship?
Deputy Commissioner of Police.
This part is not made.
You'll have to amend it then.
SP Kamrup Metro.
SP Kamrup Metro is not there.
Actually, it should be Commissioner.
ACP border. Well, then don't say this. Say that. It is the third so and so. The next part, the honest standing counsel for the FT and border matters has submitted that in Kamrup Metropolitan in Gauhati, within Kamrup Metropolitan District, there is no office of Superintendent of Police Kamrup Metro, and it should be Deputy Commissioner of Police Kamrup Metro. Next, the court is inclined to direct the registry to allow the petitioner, the learned counsel for the petitioner to make necessary correction in the cost title of the in respect of respondent for under his signature before which should be done within in the presence of the AOJ with the bracket FT section. Thereafter the system, the CS system of the court may be updated. After corrections are made, the matter will be listed again for in the motion column.
Yes, sir. Some date may be fixed in by the time I shall do the correction.
It will automatically come. Once you do the correction, it will come.
Then it will come. with the motion.
Obliged.
Item 10. Item 10 for motion.
But here we are challenging the impugn order dated 9/1/2026 at page 48. And the FT case is still pending in the lower court, wherein a petition was being filed for reducing additional documents. And it was being rejected only because it was in the argument stage. Whereas the section 9 of the Foreigners Act Says the onus lies upon the proceedee to prove that she is not a foreigner. So there are vital documents.
Have you produced the order sheets of the tribunal?
Yes, Lordship, at page 49 is the impugn order that we are challenging.
No.
Yes, sir.
This doesn't help us. We want to know the entire proceedings, how much time you actually took in the proceedings.
The case is in the argument stage, Your Lordship.
We are not concerned with that at all.
Yes, sir.
This is a FT case of 2012,
Yes,
sorry, 21.
21.
No, 21 or 12? 12. So if it is 12, then it is 14 years. We want to know how the case proceeded.
For that, Your Lordship, the LCR will be required, but the next date is fixed on
You
3/10,
can't help it.
on 3/10/2026. Otherwise, the writ petition will be in fact, says the
You
same.
can't help it because you don't know. 14 years is too long a period to give you a further opportunity.
Discuter issue করেছে এটা কবে পড়ে আছে 12 কেস হলে কি হবে?
You have filed your evidence on affidavit
Yes,
on 6/8/2024.
yes.
Now this prayer has come up belatedly in
26.
2026 after 2 years. It's something we can't allow.
Also, in a similar matter, I have annexed herein at page 34. It was being allowed, stating that the reasonable opportunity should be granted.
Reasonable opportunity can't be 14 years.
Now, Lordship, that is, the case has started. We have,
No, that's why we wanted to know. You see, we asked you only one question.
yes, Lordship.
If it is a case of 2012, then it's 14 years down the line. Your evidence on affidavit is 2024. From there also 2 years.
The written statement was being filed in the year 2023.
No, we forget that. Evidence on affidavit is 2024.
Yes,
For that 2 years, how much time would be reasonable?
My friend was working 2 years of 2018. Agreed by the order of 2018 only, it will support time was done. Not the period of.
No, we didn't notice that. Which one is that?
That is page 35. Next
It's
page
35.
35 next.
that is the order of a different case.
Because it was sent back, that is why we should discuss. Say, your lordship till after within 4 months, if you approach to 11.
We'll resume at 2. Pick it up again at 2. Yes, item 10.
Yes, sir. Actually, I have received a notice. The notice was issued in the year 2023. Though it has been registered in the year 2012. And after receiving the notice, it was fixed for appearance in the year 2023, 13/9, and he appeared that day itself. And the WS was filed within 1.5 months and 2/11/2023.
Okay, Mr. Sharma, we're issuing a notice about 10 days time. In the meantime, you go through it and then respond to it.
If you notice now, Lordship, it's a Gauhati case, Lordship, regarding the signing of additional WS during the stage of argument, Lordship, all these issues have been decided in 2021, 102-799. Yeah, at least
20?
Lordship, I think Lordship, it is
2021?
2021, 102-799. Nilvan, NILBHN, in bracket MUSS. And Lordship, this issue is being discussed in this case, I think, Lordship. So I think, Lordship, it can say, Lordship is not prepared in this case, Lordship. Where I am making Lordship,
What is the document you are now wanting to introduce?
My petition is at page 37, 38. At the below, there is an enclosures therein. That is the Dolarpar Government High Secondary HC Madrasa Certificate, NRC document of 1951, Gauhati University admit card, that is of the 1962, and certificate of Cotton College of her father, that is of the 1962-64. And apart from this, there are three documents that were submitted before the court was in Xerox copies instead of the originals. So they wanted to submit the original copies in lieu of the Xerox. And further documents they want to annex are the passports, some land documents.
Page 48 and 44. Yes, 45 is the final. They they could procure only the certificate of the father of the admit card and this certificate. I have the originals with me also. Yeah. The past certificate, party could procure the same.
I think you see this or on this incident that we are.
Worship the petition, your worship will find at page 37.
Cotton College certificate 1964. Gauhati University administered. Xerox copies there also. Xerox copies there are original degrees. Xerox copies. The copies of the exhibit documents, your lordship will find at page 27 in the DWs. There has been listed as exhibit 1 to 14. Copies of the exhibited documents, your lordship, I do not have each and every document also. The voter list and all I do not have.
Of documents which are not, for which there is no pleading.
The documents that we want to produce before the court,
Without pleading,
other
you want
documents that
to-
we have.
Without pleading, you want to introduce documents. It has to be recited in limine.
We have mentioned the documents that we are gonna produce before the court after we
No,
WA.
even I want to produce things before the court. Can I do it? I want to disrupt the judicial proceedings. So what I do is that for the entire last year, I have the copies of Assam Tribune. Whether it is relevant or not, I annex all the 365 newspapers as an exhibit in my evidence. Can I do it?
The lordship, the matter was actually fixed on the date for argument on the day, and when Hari had to file this case, it could not copy the certified copies. In the case of lordship,
It's not a question of certified copy. We are asking you something, you are responding to something else. We are asking you a question, can any evidence be brought in on record without pleading?
no,
Then your petition doesn't stand a chance. Still, we are wanting to look at the documents. You produce it on Monday.
yes, sir.
If you can produce it, we can see it. If it has a link, then it's okay. Otherwise, although we may have sympathy, but can't help it.
Lordship may grant some more time, your lordship, on before 6th of March. The matter is fixed on 10th of March.
You want it when?
By 5th of March.
Not fifth, we'll make it 6th then. Both sides are represented on the day made by Land Council. By Mr. S. Ahmed, Land Council. List on 6/3/2026. We're sending you back this.
Okay.
Item 11 for motion.
May please, your lordship. Lordship, it is Red Jurigata matter, and I was declared as an Indian by the Foreigner Tribunal number 1, by order dated 12/7/2023, which is at page 41, lordship.
Item 12 for motion.
Yeah. Lordship, the contested matter. So.
Supplementary item 38.
May it pleases your lordship. May it pleases your lordship. It's an ex parte order, lordship. Impugn order is at page 22. And I have annexed the order sheet also, lordship, from page 24, lordship. I humbly pray for one chance, lordship. Petitioner belonged to yes, lordship. And she belonged to the marginalized community, lordship. I am appearing as a legal aid counsel. And lordship, she belongs to the indigenous community, lordship. She is from Goria community. I have stated in my additional affidavit, lordship, at page 80, 79 paragraph starts, lordship. Hmm? Opinion, lordship, is at page 22, lordship. Personally not, sir. Son has adult. Son is also adult, lordship. This is the reason I'm not urging. And she has received, means her son, personally she has not received, but son has signed that. So, and he is adult. Hmm. I cannot. So he's an adult member, so he has received the notice. So I'm not arguing on that point. One chance, lordship. And that also it's too late approaching this honorable court because of extreme financial condition, lordship.
As per section order 5C, Lordship, Foreigners Tribunal Order 1964, notice was duly served, Lordship.
I'm not questioning on that. I'm not arguing also on that. I have received, my son, adult son has received. So I'm not arguing on that point.
Lordship. I was questioning. If there is any information, any lower apparent of face of the opinion, then Lordship may interfere, but Lordship, there is no apparent on the face of the opinion, Lordship. No, there is no infirmity in the opinion passed by the learned tribunal, Lordship. Notice was duly served, and Lordship, after 8 years, Lordship, he approved before this honorable court.
A proper inquiry would have been instituted because she belongs to the indigenous community. And recently I was going through one article in Live Law wherein it was stated by Honorable Justice Bhuiya. So the misfortune, it's really a misfortune, Lordship. A proper inquiry would have been conducted. He won't have been before this Lordship. Deeply, my Lordship.
Time being item 12.
Remind. In context matter and impugn order plus 85. 85 no. By order 13/6/2024.
But Saira Khatun is apprehended. She shall not be deported out of the country without order before. The petition shall bring. They shall cause production of the certified copy of the order before the Superintendent of Police border. His place? Nagaon. Bring the order to the notice of the said authority. Now, what is the correct spelling? In page 85, Khatun is written differently. And in this repetition, you have named differently. Which is right?
Sometimes it is written as in the Aadhaar card also TUN. But in the notice it PW.
Okay. This was give a date performance.
But
27th of March.
Upgraded item 29 for orders. Item 27 for orders.
This one, this one. There's no representation, the Commissioner on call. All the respondents are represented. For bench of justice, the magistrate John today. List again on 11/3/2026. Yes, item 28. 28.
Item 28 for orders.
Now, if there is a call for the petitioner, how the respondents are fulfilled. Take notice of the fact that by order dated 25/11/2024, this court had recorded that the petitioner number 1 had expired with court. Court also takes note of the fact that by an order dated 27/10/2025, this court had recorded the submissions, the submission made by the non-counsel for the petitioner that he would be filing an interlocutory application in the course of the day. So as per office note dated 31/10/2025, no interlocutory application has been received by the concerned section till date. Next. Accordingly, this review petition stands dated on death of the respondent number 1. That the name of respondent number 1 be struck off. At the risk of the petitioners. Next. For next for ends of justice. The matter stands adjourned in respect of respondent numbers 2 to 5. Next, it is made clear that the petitioner remains unrepresented in the next date of district. Those orders go. Next, list again on 11/3/2026.
Item 29 for orders.
Then appears for the applicant on call. All the respondents are represented. Next one. This interlocutory application was filed on 26/6/2024. By this interlocutory application, the applicant Anwara Begum, who is the petitioner in the connected petition in the connected WBC 7866 of 2017, has prayed for correction of the typographical error. It has inadvertently appeared in paragraph 6 and 7 of the order dated 29/5/2024, passed in the said petitions. Here is to substitute the authority referred to as Superintendent of Police border within bracket border from Ojali. And to be read as Superintendent of Police within bracket border. This is Gauhati. Where is allowed. After considering the submissions made by the CCC from State and Departmental Council. Accordingly, covered. The Superintendent of Police border Ojali appearing in paragraph 6 and 7 of the order dated 29/5/2020 passed in WC 7866 of 2017. And now we read as SP Superintendent of Police border Corpeta. This and is extended for 10 days from the date of the order for the petitioner to appear before the Superintendent of Police within bracket border bracket was Corpeta, and take bail in terms of the order passed on 29/5/2024. Next paragraph. In the event the petitioner, the applicant appears before the said authority within the time extended time. The said authority shall do the needful in terms of order dated 29/5/2024 passed in WC 7866 of 2017. This application stands allowed and disposed. You show the presence of Mr. A.M.
I mean, like, how many days
In the main petition, you say both sides are represented. Okay, sorry. Oh. No, Mr. Ahmed, you'll have to file a fresh application for bail also.
Miller.
The order has already been vacated. The bail order granted to you has vacated by virtue of order 29/5/24. Automatically you can't have it restored. Mr. Sharma, please look into that order.
No, it shall be automatically vacated. না আমি কি ইমিডিয়েটলি ফাইল করতে না you could find it immediately. No? Oh, wow. 24th June.
Okay, let it debate. Mr. Sharma, this is a mistake of the court.
Yes,
We cannot, heading is at withdrawn.
lot put.
In the main case, you write both sides are represented. Pursuant to order part 30, the record and the traveling is received.
And this one, what was that?
Same applies
Mother. After
for the consideration. Accordingly, the court is inclined to issue root returnable forfeit. Without requiring any first steps to be taken. Next, this is the matter for hearing. In the week commencing 23/3/2026.
I mean, maybe get some more time after Ramzan minute. After 18th.
No, you have already delayed for 2
Yes,
years.
that is 2 minutes.
No.
I did the fasting period minute. That's why.
No. We are extending time, otherwise we'll
I
withdraw
dare
that also.
to see the lady minute.
No.
The child and
You see, you filed
Yes,
it in
yes,
2024.
yes.
You did not never moved it.
I admit it.
No. We are not. Can't extend that amount of time.
I can just not. Then 15 days maybe. 15 days maybe from today.
You already, you see, we are.
15 days.
10 days.
Fasting.
Can't help it.
Obvious.
They never showed any urgency. Neither the applicant nor you. Both did not show any urgency.
Obvious. Very good. Very good.
You can see it's 11/3 now.
If you get this name,
11/3.
is it going to be this name? More problem. Milot, item number 27, Milot. There is no any interim order, Milot. Though Milot matter will be taken up after Ramadan, Milot.
Interim order, we gave an interim order with some time limit.
There is no interim order.
No, but in review petition, you are not getting any interim order. What sort of interim order?
Yes,
What?
No, he praying for listing after Ramadan.
After Ramadan, Milot. After 18th of
11th of March this year.
11th of March. 21?
After 18, Milot.
The 25th of March. You show his presence, Mr. A.M. Okay. Item 27, 23 plus.
Item 30 for orders.
Extension.
Extension. Yeah, please, Lordship. Lordship, the I has been filed for praying for allowing the petitioner to appear before the SP border Lordship. The order is at page 7 Lordship. And this order has not been did not comply by the petitioner Lordship due to some difficulty in the
But you, now you see you are,
2 years.
come again after 2 years.
Lordship.
You say that you have difficulty to appear before the border, prisoner for this border and take bail. And you never moved it.
Lordship,
You express so urgency in the matter.
at the initial stage, Lordship, in the year 2018, Lordship, he's granted bail, Lordship. And that order has been complied. But subsequent,
2018, you have filed this application in 2024,
Lordship,
correct?
and the order
After
passed,
2024, you are moving it now.
this order, Lordship, passed on 10/5/2024, Lordship.
10/24.
Lordship. At the initial stage, in the year 2018, bail was granted, Lordship, and that order has been complied. But subsequent to capture his biometrics, Lordship, and fingerprints, and this order he is
See
not
that?
complied.
See this file?
Lordship, the
No, when you do this, we can't even do anything. The reason is that this order is already vacated. Paragraph 10 at page 8. If the order is vacated, then you will apply for fresh bail. You can't extend that order. Then we'll be modifying the earlier order without prayer for modification. You can't do that. The coordinate bench has already what you call vacated your order. Now you have to withdraw this and file a fresh bail application. Or for releasing the petitioner on bail, fresh bail. Now, second is that when you show us the prescription, we find it very interesting reading. You have shown us page 9. This is your prescription for heart disease. Are you aware what is these medicines? Have you tried to ask any doctor what are these medicines for? No.
No, Lordship, but as per my instruction, that is, that he's
That's
was
what is very
filling.
interesting.
Lordship.
Because you see, instead of law books, I spend time reading medical books.
Oh.
That's the difficulty of the bench. PCM 650 is a paracetamol 650, not used for heart disease. Then you have a cough syrup.
Cough syrup.
Cough syrup is not used for heart disease. Third is one I can read, Namul syrup, 3 times a day, not used for heart disease. Item number 4 is zincobate. It's a vitamin, not used for heart disease. So your heart is strong. Medical is something I spend time reading it. We are telling you always, now and then. It's a pastime. I still purchase medical books and read it. And we can tell you whether you get bail or not is a separate matter. But this is a doctor you can sue and win. He is prescribing this medicine for a patient who has a heart rate, what you call, the blood pressure of 90/50. In 90/50, if he can stay alive and get this prescription of PCM, cough syrup, zincovate, then you have a very good case for medical negligence. You will be rich.
That is good. Lordship.
95/50 is no
Yes.
pressure at all.
Lordship.
Person would not have lived even for half an hour after that. The heart functioning would stop.
करने से ही खुद करा जाएगा।
So with this medical certificate, we have to reject it on that ground. This is your document, we can't help it.
Lordship.
Diastolic pressure of below 60 is unacceptable for a human survival. Okay, sorry, we are dismissing it from this ground. Your name is Mr. Muhammad Arif
N. Hawk, Lordship.
N. Hawk. But Mr. N. Hawk, learned counsel, appearing on the counsel for the learned counsel, appearing under instructions from the learned counsel for the applicant on record. Counsel for the applicant. Counsel for the This interlocutory application was filed on 10/7/2024. So by filing this interlocutory application, the applicant is seeking the applicant, namely Mafiz Ali alias Mafizuddin, who is the applicant in the connected WPC 469 of 2018, has prayed for extension of time to appear before the Superintendent of Police within bracket border, Bangaigaon, in terms of order dated 10/5/2024, and take bail. Next para. The reason assigned in this application is that the applicant was suffering from chest pain for which he could not come to Gauhati, take certified copy of the order and appear before the Superintendent of Police within bracket border, bracket close Bangaigaon, and take bail. Stop. On a perusal of the medical certificate, medical prescription issued by the attending doctor, the said doctor has diagnosed the blood pressure of the applicant as 90/50. Stop. With such blood pressure, the petitioner, the applicant was prescribed the following medicines. Number 1, tablet PCM 650. Number 2, syrup, SYRUP, syrup. Cup, COUGH. Number 3,
Nasal drop.
nasal drop. And number 4, Zincovit. Stop. None of these drugs, public medicines, none of these medicines would be sufficient to effectively deal with the low blood pressure of 90/50. Stop. Neither these medicines are found to be prescriptive medicines for heart disease. Next paragraph. Therefore, the medical certificate dated 2/6/2023 annexed as Annexure B to this interlocutory application, does not satisfy the court to sustain the projection that the applicant projection made in paragraph 4 of this interlocutory application that the applicant was suffering from chest pain. Let's come. Therefore, command. The court does not find any merit in this interlocutory application seeking extension of time to appear before the Superintendent of Police within bracket border with Bongaido and take bail. So accordingly, this interlocutory application stands dismissed. In the main writ petition, you say both sides are represented as the records of the tribunal is received. Court is inclined to issue rule returnable forthwith without requiring any test. Was that the rule is already issued? Say the records is received, also accordingly, list the matter for hearing on in the week commencing 23/3/2026.
Obliged with.
The members of the bar will have to rise for the single bench of my esteemed sister. And if anybody has any urgency in the matter,
And regarding item 23, Your Lordship, interim order is not there, Your Lordship. In the earlier opinion, it was stated that the my interim prayer will be considered after receiving PRCR. PCR has come, Your Lordship.
make it tomorrow. Item
23.
But please remind us if we have to pass orders in the morning to tell the court master. Because even tomorrow we have a.
Tomorrow, day after tomorrow, Your Lordship. Tomorrow, or day after tomorrow, at your convent.
Then Monday. No, tomorrow there are many parted matters, not tomorrow. Monday then.
Monday.
Item 24. 23. Item 23.
Obliged, Your Lordship. Monday.
Yes, represented. It's the matter, the positive time matter could not be taken up. This thought, we can.
Item 36. 36 license.
Item
Hearing.
36.
36. And that may be given now. Any date, is
okay, this will be adjourned. This is, you want an early date? You want an earlier date of hearing?
Yes.
Any date, Lordship. Is praying for any date, Lordship.
মই এটা ডেট দি দিম
26. Same order.
Lordship, item number 25, the land acquisition matter, Your Lordship. Can it be on 11th of March, Your Lordship?
11.
11th, Your Lordship. Lordship. Obliged.
Zarika, take note of this matter.
25.
Zarika? No. 11th of March for fixing. 25. Say,
I have to inform because P9 has finally.
whatever we are fixing it on 11 March. We can try. Okay, that's presented. The possible plan is not be taken up.
I will inform now. Okay.
List of 11.
Obliged.